Hey everyone, Judicial Watch President Tom Fitton here with our weekly update on social media. Thank you as always for joining us. A lot of terrible things going on in the country this past week, including a new political indictment of Donald Trump and other innocents down in Fulton County, Georgia. Obviously, I'll be talking about that. Also, Judicial Watch has filed a major new lawsuit against the Central Intelligence Agency, the CIA, for documents on their election interference against President Trump and for Joe Biden in the cover-up of the Biden scandal, the Hunter Biden scandal. And we had a big hearing this week on the January 6th videos, and I'll give you an exclusive update in that regard as well. First up is the news that I think should make all patriots upset, which is another attack by a Democratic politician, this time Ms. Willis, the district attorney in Fulton County, Georgia, who filed an extraordinary, reckless, and abusive indictment against President Trump and 18 others over their efforts under the First Amendment, the federal law, the Constitution, and their rights as citizens of the United States. In the case of President Trump, his powers as chief executive and other government officials' powers in their capacities over in the Justice Department. And in the case of Mark Meadows, his former chief of staff, he was working for President Trump at the government at the time. And what they're trying to do is criminalize the basic work of disputing an election. The January 6 indictments here of President Trump pale in comparison in terms of the scope, breadth, and abuse of power, in terms of attacking the constitutional civil liberties of many, many Americans. It's about as bad as it gets in Georgia when it comes to the rule of law. And I have the indictment here. It's 98 pages or so. And you may recall it was a circus. The clerk for the court accidentally, supposedly, posted the indictment hours before it was voted upon and finalized by the grand jury, which suggests that, in evidence first, in the process afterward, verdict first and then the process afterwards. This is an Alice in Wonderland approach to prosecutions. It's when you see this district attorney come out and say she wants to have a trial. Now it looks like the day before the Super Tuesday primaries. I think 10 or 12 states will have primaries the next day, including all 19 defendants. And, I immediately think of the Stalinist show trials, and I commented on Fox News the other day. What are they going to do? Put people in cages and have people throw things at them? But this is the state we're in when you have the Democratic Party across the country target, basically use the powers entrusted to them where they are in official positions to try to prosecute and jail their political opponents, not because of misconduct or crimes, but because they took the wrong political positions in the 2020 election. And this was my initial reaction to it here at Judicial Watch the other day. Here's my initial reaction to the fourth, if not the fifth, unprecedented indictment of President Trump. Hey everyone, Judicial Watch President Tom Fitton here with the latest on the crazed indictment of President Trump down in Fulton County, Georgia. It's all about power politics. It's not about the rule of law. And frankly, there's a national Democrat conspiracy to try to jail Trump in the middle of the presidential election. 4 indictments in about 5 months. Who are they kidding? This is nothing but politics, and most dangerously, they're trying to criminalize core First Amendment speech. They don't want anyone to dispute elections, and if they don't like what they're saying, as they're seeing in Fulton County, they'll try to jail you, not only President Trump, but other people around him who are doing their jobs under law and exercising their rights as free people in the United States of America. I think any government official, both in Georgia, here in Washington, D.C., and up in New York, have a responsibility to shut down these craven and politicized indictments of President Trump. Our republic is at stake. Do you agree? I agree with that guy. I think he was very articulate. But it's difficult to improve upon that, don't you think? We're in a constitutional crisis with the targeting of Trump. This is the fifth indictment, if you count. So you had the indictment related to Mar-a-Lago. Then you had, I think, a superseding indictment, so that's a double, so there's two. You had the indictment against Trump here in Washington, D.C. You have, so that's number three. You have the fourth indictment up in New York by Soros-funded prosecutor Alvin Bragg, a Democratic Party official, over a settlement agreement President Trump had engaged in. And now here's the fifth indictment. So that's 5 months, 5 indictments. I mean, to kind of describe it that way is to highlight the political nature. And of course, all of them want to have trials next year in the middle of the election. As I said, the Fulton County prosecutor wants a trial in March. The case up here in D.C., the government wants to go to trial against Trump in January. In Florida, they had sought a trial, I think, in December, but the judge kicked it to May. And on top of that, there are these civil cases brought by New York Democrats in which Trump is going to have to face trial either directly or indirectly. And so it's the most massive election interference operation by state and federal authorities acting under color of law. You know, this is the irony here. You know, they charged Trump with acting under color of law in one of the cases to deprive people of their whatever. I mean, I'm not sure what he's depriving of who's being deprived of any rights when he challenges an election. But here this is what the government is doing, is they are using the power they have under color of law to deprive Trump and try to deprive Trump and others of their civil liberties. And in the case of Georgia, they've used this racketeering statute in Georgia, which is pretty broad. And as you might remember, racketeering is usually used against the mafia. It should have been used against the Biden family and still should be used given the nature of their activities. And in order to generate the racketeering charge, the Georgia prosecutor goes through and lists a series of acts, right? And she calls them overt acts. And they're all virtually innocent, lawful activities by the individuals, either those who are indicted or those she calls unindicted co-conspirators. And so Mark Meadows asking for a phone number is an overt act and part of this conspiracy. A Department of Justice official asking another Department of Justice official, you know, to consider drafting and sending out a letter saying the Justice Department is investigating voter fraud, that's another overt act. All of which is legal, right? Legal activities, but they're saying are overt acts in furtherance of a conspiracy. Now, when you point out the absurdity and the abuse of basically highlighting First Amendment speech and calling it part of a conspiracy, the left comes out and says, oh, no, we understand that. This doesn't mean it's illegal. It's just part of the process in charging a racketeering case. But you're accusing people of engaging in a conspiracy. So don't pretend it's, you know, just because it's listed seemingly absurd, you know, where they're trying to, for instance, put Mark Meadows in jail for asking for a phone number. Don't pretend that it doesn't mean what it says it means, which is that they are trying to criminalize obviously innocent activity to try to jail Trump in the middle of the presidential election campaign. Now, we've known this is coming for some time, and I want to know what Georgia's going to do about it. Because last I checked, the DA of Fulton County isn't the king of Georgia. The state government obviously constitutionally has the ability to rein this in. And the question is the state government, the state governor, the legislature, and other responsible officials going to stand in the gap for the rule of law and shut this down? And if not, why not? And I think certainly if you're a voter in Georgia, and other citizens have a right to communicate with the government of Georgia as well, you should be asking them what are they going to do, and if not, why not? Now, my understanding of the pardon process in Georgia is that under the current rules, there's a kind of a committee that only pardons people after they've served their sentences, more or less. I'm not quite sure if that's a law or regulation, but it doesn't matter. Let's say it's a law and it has to be changed. Well, then the law should be changed to allow a governor or another responsible official to pardon people directly so that they can pardon Trump and these other innocents who have been attacked here and maligned. I mean, they're going after Donald Trump, Rudy Giuliani. Some of these are friends of Judicial Watch. I mean, we're friendly with Giuliani, John Eastman, great man, Mark Meadows, another good guy. Who else do I know here? Jenna Ellis, another friend of Judicial Watch we've been friendly with in the past. And it looks like, and Sidney Powell, a fine lawyer, and it looks like a whole host of other citizens and public officials and campaign officials who were exercising their rights under law to challenge an election. And what she supposes in this case is that the questions about the election in Georgia had no basis. And that's a lie. Dare I say it, this indictment is an overt act in a Democratic Party conspiracy managed by Joe Biden and his appointees and political party allies in the party and in Congress and in the states and in the Justice Department to deprive Americans of their right to select a president free of malign interference by the federal government and state officials such as Alvin Bragg and Ms. Willis in Georgia. Okay? Two can play at this game. They're trying to deprive you of your civil right to vote by essentially taking away a candidate unlawfully. And the law doesn't allow that. So, but of course the Justice Department's part of the conspiracy, so they're never going to indict themselves. So Governor Kemp can bring back the legislature early on an emergency basis to deal with these issues, to rein in the district attorney, change the law to eviscerate this case, change the law to allow pardons so that all of this can be shut down. But Governor Kemp doesn't like President Trump, and evidently he doesn't want to do this. On top of that, Congress, which is in the middle, as I talked about last week, of a 7-week vacation. 7-week vacation. They call it the August recess. Now, their definition of an August recess is, I guess, the end of July through the middle of September. Congress, at least the House, is not coming back until September 12th. So Speaker McCarthy considered this to be an emergency. He'd call the House back and start taking action. And as we've been discussing here, and some others have highlighted, there's not a darn thing that's going on that you don't like here that Congress can't do something about. They can defund Jack Smith. They can, for instance, refuse to allow funding for Fulton County or New York City or maybe even the state of Georgia. If all of Georgia, their political establishment wants to turn our presidential elections over to one district attorney and a judge, I guess the judge who's assigned, I don't know if he's a good judge or not, but he's been on the bench 6 months and he's 34 years old. So, you know, he's probably had not much experience. But, I mean, he could be the best judge in the world, but should he be running our campaign, presidential campaign? Should Judge Chutkan be running our presidential campaign, or Judge Cannon? I forget the name of the judge up in New York, but we didn't vote for these judges to run our presidential campaigns. And we shouldn't tolerate politicians abusing their powers to try to jail their political opponents and undermine our republic in a way it's never been undermined in American history. So if Congress wants to do it, they can shut it down. They can defund this. They can curtail funding for the states until they start respecting the civil rights of their citizens. They can demand criminal investigations through funding restrictions and requirements of not only what's going on in New York and Georgia, but what went on here in Washington, D.C., not only of the Biden corruption, but the Justice Department corruption to cover up the Biden corruption. And as I noted last week, maybe they don't fund government. Maybe we have a government shutdown until Biden resigns. I mean, you just can't come out and say Biden's the worst, most corrupt person in the history of the world and then do nothing about it. And that's what they're expecting us to tolerate as voters and as citizens. They'll just complain and complain and not do anything. And they get documents, which is good, and they do hearings, which is good, and it's much better than in the past from our friends in the House. Jim Jordan's been doing good and doing a good job, and Comer has been doing a good job as well. He runs the Oversight Committee. But it's not enough. It's necessary, but not sufficient, right? And so we need to clean house and protect our republic from those who would undermine it and those who are attacking it. I mean, just this week, you also had them attacking the Supreme Court again, trying to pressure Justice Thomas for violating ethics rules that aren't ethics rules. So they make up ethics rules and say that he violated them. I mean, there's this constant, deliberate effort to undermine every civic institution, every constitutional institution, so that they can get their way in terms of policy and politics. And when things like this happen, both the charges in Washington, D.C. and the charges in Georgia and New York, we go into a post-constitutional period. Now, does it mean we can't get back to constitutional government? No, of course it doesn't mean that. So I'm not saying that the country is over, but I'm saying it could be over unless we recognize what's happened and try to fix it and mitigate it and hold those responsible who have violated our constitutional system in an appropriate way. And that means defunding them, prosecuting them where appropriate. Certainly we shouldn't tolerate what's going on in Georgia and New York and here in Washington, D.C. And so if you're concerned about this, and certainly if you're a Georgia resident, you should communicate with your elected officials there. And in Congress, you can communicate with Congress saying, what are they going to do? They have a trick to end this. It's called turning off the taxpayer spigot of funds. Or if they turn it on, it's only with certain requirements. And the question is, are they going to do that? And if they're not going to do it, maybe they don't care about this corruption. That would be the conclusion I would draw. They don't care about it. And they're happy to see the country fall apart because it's too politically difficult to do the right thing. And I'm not talking about Democrats. I'm talking about Republicans in this regard. So this is an attack on the First Amendment. The 12th Amendment, right? That's the amendment that guides how our elections are supposed to be run. The 14th Amendment. The 6th Amendment, they're trying to outlaw legal advice. If you get legal advice they don't like, they want to put the lawyers in jail. And what they're effectively trying to do is freeze the presidential campaign of President Trump and the entire Republican Party. Because effectively, when you read this indictment, when you look at what the Justice Department, the Biden regime is arguing, they're saying any communication effectively that President Trump might have with anyone about any of these issues could be subject to scrutiny by a criminal court. And he may have to answer for in court. And anyone talking to him may have to answer. I know in this case, in this indictment, it looks like some people have commented, it looks like they're trying to slide Judicial Watch into this mess. And I know already we've been called as a witness in this case up here in Washington, D.C. I told you about the grand jury appearance I had to suffer through for 4 hours of political debate with these Biden prosecutors. So as Trump has said, he's right. It's not just about Trump. They're trying to get him, but they're also trying to get you. If you are an opponent of the Biden administration, you have concerns about election integrity. And it's not just these prosecutions of Trump. I think it was in Michigan they're targeting those who are involved in trying to get alternative slates of electors going. They're trying to criminalize being an American. And I talk about the election interference, and the Justice Department, for instance, is wanting, as I said, to move their election sham case, begin it in January. I think they want to do jury selection in December. So 4 months from now, more or less, right? And President Trump and his attorneys filed a brief opposing it. And I'm going to read you a little bit from the brief because I don't want, because my guess is Trump isn't going to get what he's asking for from this judge. But, the media is never going to tell you how outrageous it is. He's not going to get what he's asking for. And I want you to know just how outrageous what the Justice Department is doing against Trump here by reading a little bit from this brief. And it starts off as follows. The prompt, and this brief was filed this week, asking for a trial date of April 2026, not January 2024 for this complex case. The prompt disposition of criminal cases is to be commended and encouraged, but in reaching that result, a defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. To do that is not to proceed promptly in the calm spirit of regulated justice, but to go forward with the haste of the mob. And that was a quote from a case. And his lawyers go on to say, this is an unprecedented case in American history. The incumbent administration has targeted its primary political opponent and leading candidate in the upcoming presidential election with criminal prosecution. The administration has devoted tens of millions of dollars to this effort, creating a special counsel's office with dozens of employees, many of whom are apparently assigned full-time to this case and this case alone. Taking full advantage of the administration's blank check, the government spent over 2.5 years investigating this matter. It, among other things, interviewed and subpoenaed hundreds of witnesses, executed over 40 search warrants, and compiled information from countless individual sources. The government included some, but not all, of these materials in a massive 8.5 terabyte initial production totaling over 11.5 million pages, together with native files, recordings, and other electronic data not amenable to pagination. So meaning if someone, let's say it's an audio tape, you have to listen to it. You can't print it out. In this district, ordinary order, and this district being the District of Columbia, ordinary order, when faced with such overwhelming discovery, is to set a reasonable trial schedule commensurate with the size and scope of discovery and complexity of the legal issues. The government rejects this sensible approach. Instead, it seeks a trial calendar more rapid than most no-document misdemeanors. Okay. They want to move this case faster than no-document misdemeanors. So a misdemeanor case, right, a low-level criminal case where no documents are at issue. And they're requesting just 4 months from the beginning of discovery to jury selection. The government's objective is clear: to deny President Trump and his counsel a fair ability to prepare for trial. The court should deny the government's request. The public interest lies in justice and fair trial, not a rush to judgment. Moreover, if the rights to due process and counsel are to mean anything, a defendant must have adequate time to defend himself. The Speedy Trial Act embraces the considerations, and so too should the court. And so accordingly, they asked for an April 2026 trial date. And there are, as I said, there are 2 other cases up in New York, civil cases targeting Trump. He has now 4 sets of criminal charges facing him, all of which they want to adjudicate in the middle of the primary. And by the way, he's been out of office since 2020, right? 2021. And why did they wait till just now to drop all this on him? It's obvious campaign interference. Obvious campaign interference. And they highlight that if you were to stack the 11.5 million pages of documents, on top of each other, it would be 4,822 feet. And that would be significantly bigger, probably 8 times bigger than the Washington Monument in terms of length. So it's a lot of documents. And of course, this case isn't even a usual case. There's been nothing like it in American history. And that's what also the lawyers point out. They say this case is not just complex or unusual, it is terra incognita. The protests at the Capitol aside, no person in the history of our country has ever been charged with conspiracies related to the Electoral Count Act. No president has ever been charged with a crime for conduct committed while in office. No major party presidential candidate has ever been charged while in the middle of a campaign, and certainly not by a Justice Department serving his opponent. These and numerous other issues will be questions of first impression, requiring significant time for the parties to consider and brief, and for the court to resolve. The proposed schedule provides that time, meaning the Trump's proposed schedule. The government's timeline does not. Consequently, the complexity and unusual nature of the case favors what President Trump's attorneys are trying to promote. And these are some of the details, and this is interesting. So this is why I'm going over this with you, because when the trial date is set, and I suspect that Judge Chutkan, the Obama appointee in this case, based on her comments at that hearing, some of which I thought were unusual and a bit intemperate given the circumstances she's under, she wants to move as quickly as possible with this trial. And I suspect she's going to try it next year. But we'll see. Maybe she'll do the right thing. Indeed, the median time from commencement to termination of a jury-tried 371 charge, I think that's a conspiracy charge, maybe, is 29.4 months, many times longer than the government's proposed schedule. And this reflects only the median, meaning half of all such cases take more time based on an individualized assessment of discovery volume, complexity, and similar concerns. Now, Judge Chutkan, as the Trump attorneys carefully point out, allows far more time than the government proposes, even in cases involving protests at the Capitol. And there's one charge where it was 28 months from indictment to a stipulated bench trial on a 4-page indictment. So it's over 2 years on a 4-page indictment on a straightforward, well, it depends how you see how these January 6 charges generally, but a relatively straightforward case. Another case, 21 months. Another case, 29 months. Another case, 24 months. So there's really no good reason to have these cases occur next year other than to try to rig an election. And the judges, in my case, should refuse. All of them, anyone who's involved in any of these cases, should have, and still should, refuse the Justice Department's desire to have them run effectively the presidential campaigns. I mean, Judge Chutkan has essentially told Trump he's going to be watching everything he says. And I've described how everything he says now can and will be used against him in a court of law. How can he campaign in those circumstances? Now, I don't know if this is legal or not, in the sense that, there's a legal basis for doing so, but I suspect courts have a lot of discretion here. If I were a judge, I'd look at this and say, you're not doing this in my courtroom, you're out. You want to do political fights against Trump, you go buy advertisements. You're not using my courtroom to run an election operation against the candidate you don't like. And that's the end of it. You don't like the ruling, go appeal it. And as a matter of fact, Mr. Prosecutor, as a matter of fact, Miss Prosecutor, I'm referring you for discipline for abusing your offices to engage in politics and target people based on politics. If justice is done, the prosecutors behind these charges at the end of the day will be disbarred and face other criminal and civil investigations. From Jack Smith on down. And Garland, of course, as well. I'm not forgetting him. So Judicial Watch will continue to investigate and uncover and hold to account all of these prosecutions or prosecutors, these offices abusing the rule of law to target Trump and other innocents. We have litigation already, for instance, against the Justice Department for the list of people who are working on these prosecutions that Donald Trump has highlighted are spending full time trying to put him in jail. Well, who are they? Why can't we know who they are? For the first time in my memory, since the special counsel's been around, they're saying to us in court, we can't find out who's working for Jack Smith. Now, every once in a while, a name shows up on a pleading in these cases, and they say, well, that's someone you can have, that's a name you can have. But that doesn't tell us who's really running the show behind the scenes or who else is involved. I mean, there are U.S. attorneys or assistants to Smith who end up on court pleadings, and you see their names, and you can find out more about them. But what about others? You know why they don't want us to find out who they are? Because it's going to be, given what happened with the Mueller operation, we're going to find out they're Democratic supporters, activists, and such, further highlighting the political nature of their unprecedented and, in my view, illicit prosecutions. I mean, the case in Georgia is based on a legal fiction, to be clear. The cases up here in Washington, D.C. are based on legal fictions that ordinary business, in the case of New York, business and personal activity, in the case of Washington and Georgia, and I guess Miami, which is Mar-a-Lago, political, presidential, candidate, First Amendment activity, that's all, it's all perfectly legal behavior that they're trying to criminalize. And what happens, I'm concerned Trump's going to be in jail next year. Somehow, some way, they're going to get him in jail. And as I've highlighted, the administration has long become, is now officially a regime as far as I'm concerned. We're in a situation of not American politics or the American way, truth, justice, and the American way. It's now regime politics run by folks who not only engage in unconstitutional behavior, but I would submit anti-constitutional behavior. And, it's not just Democrats that we have to fight for the truth, it's Republicans. And we talked about last week, and I'll talk to you again about this now. We had a hearing in federal court this week before a relatively new judge who was just appointed by President Biden, Judge Reyes, over the January 6 videos and emails that Judicial Watch is seeking from the U.S. Capitol Police. And there were, according to various court filings, 14,000 hours of video. According to court filings in our case, I think is as interesting, 271 emails that they don't want to turn over to us under law. Now, Congress is not subject, excuse me, to the Freedom of Information Act, but it is, we argue, subject to the common law right to public access to government information, right? You don't need a FOIA law to go ask a government official for certain government documents, whether they be members of the judiciary or even members of Congress. And this is a right that predates the Constitution. A common law right is the type of law that's just out there, right? It's just seen as a given. And when we first filed this case, I think it's now 2 years ago, the Pelosi Congress came to us. Their defense of this was, these aren't public records. Even if they were, there's no public interest in their release. And Congress has sovereign immunity, meaning we haven't been blessed to sue them in court on this. And this case has bounced between 3 judges. It was initially before, ironically, Judge Jackson, who's now on the Supreme Court. And then she obviously went to the Supreme Court, and it was moved to Judge Pan, P-A-N, who had the case for some time. And then she was elevated to the appeals court by President Biden, and so it sat, and then it was finally assigned to Judge Reyes, who's trying to figure out what to do. And what happened in court the other day, so it was at the federal courthouse here in the District of Columbia. Michael Bekesha is the Judicial Watch senior attorney who's representing Judicial Watch in this case. And what happens in these court cases in FOIA often is if there's a hearing and it's here and my schedule allows me to do so, I'll go over and I'll sit at the table with the attorney representing the client, the corporation of Judicial Watch as its president. So I get to sit there and I have to be polite. I gotta keep my hands folded and grin and bear it when things go poorly, and grin and bear it and be calm even when things go well in the court. And this was a mix of both, unfortunately. And on the other side were 3 attorneys, and we obviously have Michael, 2 with the Justice Department, and 1 a general counsel for the U.S. Capitol Police. So this is a case, as I said, promoted by Nancy Pelosi as being Nancy Pelosi's Congress through the Capitol Police, wanted to shut this case down, and the legal position has not changed under Speaker McCarthy. So you can imagine how frustrating it is to me to be in court against people who answer to Speaker McCarthy now on this court transparency issue. And they came at the last minute, the day before the hearing essentially, and told the court, well, you know, so public records under the common law right to access is it's much more narrow a section of records than records available under the Freedom of Information Act. You don't get everything you might think you can get. They essentially have to be final government documents showing government legal consequential actions. And one way around that, according to the government, is that anything that's, quote, security information is not a public record under the law. So what they have decided to do is, and the U.S. Capitol Police official in charge, with relevant oversight, has decided to designate all of those records as security information. All the videos are security information. So under their theory, assuming that there is a right to sue for these records under law, they're not covered as public records because they're designated as security information. All of them. So Speaker McCarthy should be asking, or be asked, why it is the U.S. Capitol Police is taking this legal position. Is he supported? He has oversight through his appointee on the Capitol Police Board, the House Sergeant of Arms. What's going on there? And they told us in court the other day that there's going to be a meeting of the Capitol Board that was supposed to take place, what's today? Friday? When was our hearing? Tuesday. It was supposed to take place Wednesday. Yeah, the day after the hearing. We don't know if the meeting took place. And where the board was going to vote to designate them, or at least it was on the agenda to consider that, and it was likely to happen. But we don't know if the meeting took place because they have secret meetings on Capitol Hill about the security of the Capitol and the conduct of the police. The U.S. Capitol Police, by the way, is the only police agency in America, as best I can tell, that isn't subject to basic transparency requirements that other police agencies are subject at the local, state, or federal level. It's a law unto itself in terms of transparency. So I don't know if the secret meeting took place or whether they're going to bless this Capitol Police position that all those videos are secret records because they're, quote, security information. They're obviously not all security information. That's necessarily an abuse. And I want to know what Speaker McCarthy is going to do about it. Is that going to be his legal position? Because he has at least one vote through his appointee. So the hearing went the way it went, and the court did demand, order the government to give us a bit more information on the emails that it was seeking to withhold. There are 271 emails at issue, not all of which we'd be able to gain access to, even if we were right that they're public records that should be released, because, as I said, some records would automatically be exempt from public disclosure, but other records wouldn't. Why is McCarthy sitting on this? I mean, there's the issue of this case, but of course he can just release them all. I know he's released a few videos or granted access to some on the January 6th videos, but these videos aren't generally accessible to the American people under law. Why is that? What are they hiding? I mean, I know Nancy Pelosi has a lot to hide. I mean, she was responsible in part for security that day. I mean, that's a Pelosi riot as much as anything, because the lack of security led in part to that disturbance. So, no excuse for this. So Michael Pekesha and I came out of the courthouse, and I talked to Michael a little bit about what happened in the case. I described it to you just now, but Michael summarized it in his own great style, and certainly he's worth listening to since he's the lawyer trying to figure our way through this. So let's go to my discussion with Michael. We're here outside the federal courthouse here in D.C. Our attorney Michael Pekesha was just arguing on behalf of Judicial Watch's right to gain access to the January 6th videos and emails, and it looks like they dropped a little bit of a last-minute bomb on us by suggesting they're all security records and we can't get them.
Yeah, for the past 2 years, they've said 17 out of 14,000 hours with security information. Now they're saying that maybe tomorrow the Capitol Police Board will designate all 14,000 hours.
The judge seems not interested in designating them as public records to begin with. That's unusual. She described this as an insurrection, but the videos that have been separated and kept in a file about what happened that day aren't public records. How does that work?
You know, look, everybody thinks these records are important. The public should be able to see them. Hopefully the judge is going to go back and think about it, and she said she would consider the argument that when these records were pulled out of the normal process and, you know, they were created new, and at that point they were preserved for history, and we just want access to it so the American public can see, you know, all the video from that day and decide for themselves what happened on January 7th.
Well, as you can tell, we were outside in a summer windy rainstorm. I thought we did a pretty good job considering the weather. But that's the challenge we face. The judge wasn't terribly friendly to our cause. It's pretty clear she knew who Judicial Watch was. At one point, Michael said something about, you know, many people have called this issue, you know, because I raised the point about her calling it an insurrection. Michael said, well, you know, a lot of people said this is an insurrection. Well, let's get all the videos. And she just inserted herself in response, saying, well, it is an insurrection. Well, why did she have to say that? I don't know why. And, you know, it was obviously, now on the other hand, she gave us the time of day, listened to our arguments. She's unlikely to rule in our favor, but at least she's giving us the chance to make our case. And at least we're able to be in court against the entire United States Congress through their Capitol Hill Police Board to demand accountability and transparency. And as long as this process continues to allow us to gain access to the courts to hold the government accountable, even if we win, or I mean, even if we lose, I hope we win, I think it's good because we're educating you about what's really going on through the process. And you can hold those who are responsible for hiding documents, like Speaker McCarthy in part. Senator Schumer has a role to play here, and so does Joe Biden. I think there are 3 members of the Capitol Police Board who vote. The Sergeant of Arms for the House, an appointee of the Speaker, in this case McCarthy, the Sergeant of Arms for the Senate, who is an appointee of Senator Schumer, the Majority Leader of the Senate, and then the Architect of the Capitol, who is an appointee of the President, confirmed by the Senate. So all, the Congress and the President all have a role to play in hiding these records from us. And but this is an important case, and Judicial Watch isn't going to let up. We're going to get more information about what's in the emails, at least better description of what they entail, so they have so that we can and the court can figure out whether there's a good faith basis to withhold them. But I'm hoping the court sees through this canard that they're not public records. I guess she focused on the fact that under the definition of public records, they have to be, what was the phrase, created and maintained, right? And her point was, well, these were just videos that were running. They weren't created in a way to kind of show anything or do anything. They're just running. And Michael pointed out, well, no, that's not the case, because as soon as you took the videos and put them in a separate file, you created a new record, right? And so, yeah, they were created, these records at issue, for the purposes of investigating January 6th, uncovering what went on there, and all the other purposes we've learned. I mean, they're being used to put people in jail. I mean, these records are public records by any stretch of the imagination. So maybe the court will agree with us ultimately in the end. But this is what Judicial Watch has to do day in and day out. What seems to be clear-cut cases for transparency. Sometimes the courts aren't interested. Sometimes they have a weird flex, as the youngins like to say. So we'll see what happens here. And in the meantime, we can demand transparency from the House Republicans and Senator Schumer as well, because he's hiding this as well. It's hard for me to accept the notion that January 6th, allegedly, according to them, the Borg left here running Washington, D.C., is the worst day in American history, and then hide every single one of the videos from us under law, even as you use same-set videos to try to put people in jail. Unbelievable. And what's really frustrating is that McCarthy's legal position, as best we can tell, hasn't changed one iota from Nancy Pelosi's legal position on these documents. So the other big issue, obviously, out there has been the Hunter case, right? Now, they appointed a special counsel who's compromised, Mr. Weiss from the U.S. Attorney in Delaware, and one of his big moves was to pull and discard the plea agreement in the Delaware state court or federal court. And so now who knows what's going to happen. Is he going to refile it? Is he going to reinstitute the charges in another jurisdiction? Is he going to do what he should have done years ago and do a serious investigation? Is he going to investigate himself over the obstruction that he's been accused of doing by the IRS whistleblowers? You all know how that's going to work. So, not trusting the Justice Department for many of the reasons I just stated, Judicial Watch does its own investigations as to what went on with the cover-up for Hunter Biden and the government agencies involved. And one of the government agencies who has been credibly tied to election interference to help Joe Biden and hurt President Trump is the Central Intelligence Agency. You may recall those 51 Intel officials or former Intel officials who signed that letter suggesting you just ignore the Hunter Biden laptop revelations because they were likely Russia disinformation. A letter that was organized by the Biden campaign and Anthony Blinken, it turns out. Well, the CIA had a hand in getting that out, and we've sued for records about it. We filed a Freedom of Information Act lawsuit against the CIA for all communications of the spy agency's pre-publication classification review board regarding an October 19th, 2020 email request to review and clear a letter signed by 51 former intelligence community officials characterizing the Hunter Biden laptop story as having all the hallmarks of a Russia disinformation campaign. And that was just bunk. In October 2020, in the run-up to the presidential election, the New York Post reported that Hunter Biden's laptop, which was abandoned at a Delaware computer shop, contained embarrassing and potentially incriminating information about the Biden family. In a May 10, 2023 report, the House Judiciary Committee revealed that on October 19, 2020, 3 days before the second presidential debate between President Donald Trump and then Democratic candidate Joe Biden, then acting CIA Director Michael Morrell sent the PCRB, this pre-publication review board, the finalized letter for review, calling it a rush job, and quickly secured its approval. So typically when national security officials who still maintain security clearances comment on matters of national security or want to write something, they're supposed to run it by the agencies, I think, that granted them the clearance. I think. But generally speaking, they need permission from someone, especially if it's going to touch on potentially classified analyses. Because just them blessing a fact or an analysis suggests that there's an intelligence community assessment that agrees with it, which would be kind of a backdoor way to exposing classified information. So are you getting that? I mean, so if you have a national security clearance, your commentary on public affairs and intelligence matters take on added weight because the assumption is you have access to classified information that informs it. So you got to be careful what you say. And you abuse the trust when you say political things because everyone assumes that you know what you're talking about when in fact you're just making it up and abusing the security clearances that we've given to you as the American people. Specifically the president in that case. Judicial Watch filed the lawsuit after the CIA failed to respond to our May request for it. And I think we filed the lawsuit, we just issued the release recently, but we filed the lawsuit back in June. We asked for records and communications of that review board, the CIA and the CIA, including emails, email chains, email attachments, text messages, cables, voice recordings, correspondence, statement, letters, memoranda, reports, presentations, notes, or other form of record regarding that email request to review and clear the letter involving the Hunter Biden laptop, potentially having Russia involvement or being a Russia disinformation plot. Now, Jim Jordan in May and the head of the Intelligence Committee, Michael Turner, on the House side, stated that committees were conducting an oversight of the October 20th public statement on the Hunter Biden emails signed by 51 former intelligence community officials. And of course, that's the letter, that was the thing that got approved by the CIA quickly. The CIA has documents responsive to our request and necessary to our oversight. On October 19th, 2020, Morrell submitted the statement to the CIA's pre-publication classification review board, instructing it was a rush job as it needs to get out as soon as possible. The staff responded at 7:11 a.m. that it received the statement and cleared it for publication at 12:44 on the same day, which is a world indoor record if you're seeking classification approval or approval by classification authorities from the government. Morrell speculated that the quick turnaround from the review board was because, quote, they are probably afraid I'm coming back as CIA director. So they were afraid of the boss. On May 9, 2023, the CIA produced to the committees 2 emails, Morrell's email to the PCRB early on October 19, 2023, and the PCRB's response at 12:24. However, the committees have reason to believe additional documents remain in the possession of the CIA. The committees have received evidence that the CIA, or at least an employee of the CIA, may have helped to solicit signatories for the statement about Hunter Biden. According to a former CIA employee, he spoke with the review board on October 20th regarding the review of his memoir, and during that call, a CIA employee asked him if he would sign the statement. So there's a guy calling the review board, hey, I need you to review my book. So I said, hey, will you sign this statement essentially attacking Trump and protecting Joe? Government employee at the CIA. As this guy, as this CIA employee who was seeking the review for his book explained, when the person in charge of reviewing the book called to say it was approved with no changes, I was told about the draft letter. The person asked me if I would be willing to sign. After hearing the letter's contents and the qualifiers in it, such as, we want to emphasize that we do not know if the emails provided to the New York Post by President Trump's personal attorney, Rudy Giuliani, are genuine or not, and that we do not have evidence of Russian involvement, I agreed to sign. If accurate, the committee goes on to say, the committee leaders, this information raises fundamental concerns about the role of the CIA in helping to falsely discredit allegations about the Biden family in the weeks before the 2020 presidential election. They asked someone else about what this testimony showed, and he said, this to me is something that the review board, in my experience, would never engage in something like that. They were just straightforward back and forth terms of approval. The idea that they would have a comment on any other thing that they were working on, that to me is not even close to what I've experienced with them. Does that concern you? He was asked by the committee. It's all true. If it's true, it concerns me. It would be a concern for me, but sure. But I just have a hard time believing that occurred. If it did, that's incredibly unprofessional. I think it's more than unprofessional. And as I said earlier, it was the Biden campaign that was behind this letter. So this wasn't national security officials being serious. No, this was a campaign stunt to help Joe have a talking point during the debate and provide the media and, frankly, their social media allies an excuse to censor information that would hurt Joe Biden on the eve of the campaign. And I tell you, election rigging doesn't just include stealing votes or stuffing ballot boxes. It also includes unlawfully or illicitly hiding information about one candidate in a run-up to a campaign. You can rig an election by doing that. The deep state CIA, it seems, engaged in election interference, as I said, and a political operation against the American people, all to help Joe Biden and to hurt Trump. And now the CIA is ignoring FOIA law to cover up its role in the scandal, censoring and suppressing the Joe Biden laptop story just before the presidential election. Boy, oh boy. And so Congress is interested. They think there's something here. I don't know what they've done on it. I don't think they've issued a subpoena yet to the CIA, but we've issued a lawsuit, or the court's issued, or it's moved the lawsuit forward for this document, or documents about what the CIA was doing with these 51 intel officials, and were they pushing this effort to intervene in the election to help Joe Biden. So you hear the left complaining about the CIA's role in other countries' elections. Have you heard the CIA, anyone on the left, complain about the CIA's role in our elections? And remember, this isn't the first time the CIA has been caught interfering in elections. The CIA also wanted to help and be involved in the censoring of American citizens' views as exposed by the Twitter files. I think the CIA wanted a prominent role. They were denied it, so they just came along for the ride. We're attending these censorship meetings, as I recall, with big tech leadership, certainly this Twitter. So the CIA is a threat to the Republic in terms of their being willing to abuse their powers, it looks like, to censor Americans and intervene, put their thumb on the scales on behalf of a presidential candidate. So, while Congress complains, Judicial Watch sues. I wish Congress would sue more for these documents. I'm not sure what they're doing, right? But as I said, they're on vacation. They'll get right on it. September 12th when they get back. In the meantime, Judicial Watch keeps on heavy lifting all the time on behalf of you, the American people, to get access to this basic information about some of the worst corruption in countries. I want to say I was out in Chicago this past week. I had a visit with some Judicial Watch supporters, And they're all just generous and great supporters of Judicial Watch. And I reminded them we have all this important work to do, but we can't do it. And I'm talking about the work that we're doing here at Judicial Watch, obviously, without your support. And they're obviously front and center supporting Judicial Watch. And I would encourage you, if you're not already, to support Judicial Watch. If you like the idea of someone suing the CIA to figure out if they were trying to rig the election to help Joe Biden, I think you'll like Judicial Watch. If you like Judicial Watch suing to find out who on Jack Smith's team is targeting Trump, what's their name, basic information like that, then you'll like Judicial Watch. If you like clean elections, you'll like Judicial Watch, because we're in court advocating for and protecting cleaner elections. You name it, Judicial Watch is investigating it and almost always suing about it. And so I encourage you to join our movement and join our cause. Support Judicial Watch at judicialwatch.org. As I said, our republic is under attack. And I'd like to think that Judicial Watch is the #1 defender of the rule of law and the Constitution in these United States. And we can only continue to do that with your support. And with that, I bid you adieu, and I'll see you here next week on the Judicial Watch Weekly Update. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.